Welcome, everybody. My name is Paula Price, and I'm with the People's Law School, and we're here today to talk about neighbors, in particular, dealing with neighbor disputes. What are your rights? I just wanted to acknowledge that it's Access to Justice Week in British Columbia this week. And part of what the People's Law School does in terms of access to justice is creating these webinars through which we're able to reach British Columbians across the province. And it turns out from individuals across Canada. What you can expect today over the next 60 minutes, we're going to be answering questions about neighbors. This is a webinar that provides legal information, not advice, and it is current as of today. If what you're looking for is the law as it relates to your particular set of circumstances, then I would invite you to reach out to a lawyer, possibly our speaker, Dave Turner. His information is on the screen here. And last but not least, before we introduce our speaker, we just wanted to make a few acknowledgements. The first is to acknowledge that the land on which the People's Team is gathered is the unceded territory of the Coast Salish peoples, and that is made up of the Musqueam, Squamish, and Tsleil-Waututh nations. And we extend that acknowledgement as it applies across the province and across Canada. We would also like to acknowledge the Law Foundation of British Columbia. They are our primary funder, and they make programming like this possible. And without further ado, I would like to introduce our guest speaker, Dave Turner. He is a partner and litigation lawyer at Edwards, Kenny and Bray in Vancouver. And this is the first time that Dave is joining us on a webinar, but it is not the first time that he has presented for the People's Law School. He, for about 10 years, has been making appearances at public libraries, speaking about employment issues. And so you may recognize him from one of his earlier seminars. And it turns out he also follows in his father's footsteps, who volunteered as well with the People's Law School. So the history goes back quite a ways. So welcome, Dave. It's so great to have you here. How are you today?
I'm good, Paula. Thanks for having me.
It is such a pleasure, and we're so excited to have you speak today.
I'm happy to be here.
Fabulous. So we're going to move into some questions, and these questions for everybody who has tuned in, these are questions that come from those of you who have written in to the website. So the first question is, my upstairs neighbor has a dog that barks a lot when my neighbor isn't home. I've tried talking to him about it, but nothing has changed. Can I ask my landlord for help?
There's a long and a short answer to this. The first one is yes, you can ask your landlord for help, but it helps to have some background too. My thought is that the process that this person has employed by already trying to talk to your neighbor about it is 99% of the time the right first step to take. If that doesn't work, then it's good to know what your legal stance is. And a lot of the questions about neighbors come down to a legal principle called nuisance. And so I'm going to talk about that briefly because it'll hit on a few different questions as well. But the courts, and importantly, the Civil Resolution Tribunal, which I'll refer to as the CRT today, has a few different definitions of what constitutes a nuisance. The essence of it is that it's an interference with an owner's right or an owner's use or enjoyment of land that is substantial and unreasonable. That unreasonable is an important part of it. It doesn't matter if it was intentional or negligent or non-faulty conduct, so long as the harm can be characterized as a nuisance. When you get into stratus, they change it a little bit, but it's this wording of got to be substantial or non-trivial and an unreasonable interference in the use or enjoyment of property. One that was just recently used by the CRT earlier this year, like 2021, used this word as it was an unreasonable, continuing, or repeated interference with a person's enjoyment and use of their strata lot. So the question with the dog barking is, yes, you can ask your landlord for help, and what you're going to want to say is, look, you're experiencing a nuisance here. And why is it a nuisance? It's because the question is the dog barks a lot when he's not home. And we understand from that it's ongoing because he's already talked to the neighbor, nothing has changed. So it keeps going on and on. So you've got that component of assuming it's really loud and it is enough to be a nuisance in terms of it's being unreasonably loud and bothering you and impacting your quiet enjoyment, you also have this continuing or repeated aspect of it as well. So you go to your landlord and say, this is what's happening, and it's interfering with my quiet enjoyment. Now, your landlord is subject to an act called the Residential Tenancy Act, and your tenancy agreement, which is probably the standard form that's issued by the residential tenancy branch, has a clause in it that says that you are entitled to quiet enjoyment. So you go to your landlord and say, look, my contract with you is that I'm entitled to quiet enjoyment. I'm not getting that because of this neighbor. You have an obligation to do something about it. And at that point, your landlord essentially has to help you and take care of it. And if they don't, then you've got a remedy. If it comes to that and you can't negotiate it out, then you've got a remedy, and most likely you're going to the CRT to address that with your landlord and maybe the neighbor.
Fabulous. Thanks, Dave. So, I mean, it sounds like what we're looking at with nuisance is that unreasonable interference. So you have to, there's a certain level where it doesn't reach that threshold, and where it does, that's where you've got that right to change that. And if it's with the landlord, as you've discussed, they have legal obligation to take steps to help you.
Exactly. Yeah. And a lot of these CRT cases are analyzing whether the noise is sufficient to constitute a breach of that right of quiet enjoyment. So if you get into the CRT, I really recommend a person read these cases about noise and nuisance, and it'll give you a really good idea of what kind of evidence you need to show the CRT that you really are suffering. And there are noise logs where it's sort of a diary of what the noise is. You've got examples of people using their cell phone apps to record the decibel level of the sound. And you've got the strata sometimes saying that's not sufficient. And you've got a lot of battles over what is constituting this noise. You've got witness statements come in too. But if you get to the CRT, there's a lot of information out there about what kind of evidence you'll need to show that that noise is loud enough to be a nuisance.
Exactly. And for anybody who's interested, you can go online. The CRT, the Civil Resolution Tribunal, has a website, and you can search the decisions. So you could plug in sound or noise complaint and see the type of cases that Dave is talking about. And that would apply, I believe, is it 5,000 is the threshold? If your claim is under 5,000, then that's one avenue that you may be able to pursue.
That's right, Paula. And I'll go into that just briefly, even though I haven't been asked it. The CRT website's really useful. It's got a good, if you get to the decisions page on the website, there's an advanced search feature, and it's really helpful. If you can look, that give you the leading cases from the CRT right away, and you can plug in, for example, nuisance, strata, and toddler, and you'll get a case about a toddler upstairs walking with heavy toddler type steps, and whether that would be a nuisance or not. And in that case, there's a TRAN case. There's a lot of information about what kind of evidence you'll need to actually prove it's a nuisance.
Absolutely. Absolutely. Here's our second question, Dave. And this is another question that we see a lot. My neighbor smokes, and the smoke drifts into my windows. It's been okay over the winter months, but I know it's going to start up again in the spring. What can I do?
So even though it's obviously a lot different in sound, we're still dealing with this idea of a nuisance. So the smoke, smells in general, everyone expects that there's going to be some smells coming from your neighbors, especially in a strata situation where your windows are probably in fairly close proximity together. And it's all in the eye of the beholder to some extent, but smoke is one that everyone agrees that if you're not a smoker, it is unpleasant. So it has to be fairly strong, but there are remedies for this. It has to be so that you can prove it's sort of a strong smell and it's coming in, and you're concerned about, say, secondhand smoke, for example. The first thing you can do, or first thing you should do in most situations, is to approach them directly. There's examples of these working out where simply your neighbor changes their practices and will go for a walk when they want to have a smoke. Um, but if that doesn't work and they're still unreasonably interfering in your private or your right to enjoy your use of your private property, then you get into this nuisance again. There's in smoking situations, you've got factors that are actually listed quite helpfully on the People's Law School website. In this situation, that's you got to look at what's causing it. So in this case, something you're smoking, how intense it is, how long it lasts, how often it occurs, and how it affects your health and the environment. And a lot of those overlap with that idea of it being a repeated or continuing problem to get to that nuisance level. So if you meet all those thresholds and it is serious enough to be considered a nuisance, you get over that bar of showing it's hard enough, then you can get into what you do about it. And typically in the strata situation, your first step will be to go to your strata. And the first thing the strata will probably tell you is whether in the bylaws, if you don't know it already, the strata bylaws say this is a non-smoking strata. And some stratas have that in their bylaws, some don't at this point. If it's a non-smoking bylaw, then you're in really good shape for getting this dealt with, because of course the neighbor who's smoking is going to be breaching the strata bylaws by doing so, and therefore the strata has an obligation under the Strata Property Act to deal with the breaches. And they can issue warnings, they can issue $200 fines or up to $200 fines, but they have a remedy. And if they don't do that, then you have a right against your strata. And you see a lot of those cases in the CRT where people are complaining about their strata not doing stuff after they've been reported with a nuisance, including smoke, including noise, all those types of cases. The smoking one has one added complexity, and I don't think this changes anything about what you do in the initial stages. You still should go talk to your neighbor. You still should go to the strata if it is bad enough to interfere with your quiet use and enjoyment of your property, i.e. it's a nuisance. But your CRT case may not be quite the slam dunk you think it is, because I don't want to get into it too much, but smokers generally would say they are addicted to what they're smoking, so tobacco most often. And because it's an addiction, it constitutes a disability under the Human Rights Code. So the strata dealing with this has to balance these issues of protecting, the person that we'll call it, the victim of the smoke, essentially, the person who's receiving the unwanted smoke and it's interfering with their quiet use and enjoyment. But because of the Human Rights Code, the strata also have the duty to protect the human rights of the smoker. So you see these cases where stratas are found both to have not protected the rights of the smoker under the Human Rights Code, which is brought in the Human Rights Tribunal. And at the same time, they've been found not to have done enough to protect the victim by enforcing its bylaws, and they're fined under the CRT. So they get complicated. And I just raised that if you are going to go to the CRT on a smoking issue, you should read these cases. I don't want to say necessarily hire a lawyer to look at it for you, because that can get really expensive. But it is worth looking at those before you march into the CRT and expect a slam dunk decision.
Thank you so much, Dave. That's so interesting to think about it from that perspective, that there may be that human rights defense on the other side of a complaint like that.
Yeah. I think it surprises a lot of people. Yeah.
It does. It surprised me. So thank you for making that point. And I've been studying the People's Law School web pages on these topics. And for anybody who's interested, I highly encourage you to check them out, because there's a lot of excellent information and really useful. So we have a question about parking, and we're actually going to turn it to participants. We're going to run a poll. So if we put the poll up on the screen. I'm not seeing the poll. Oh, here it is. So, does a resident own the parking space on the street in front of their home? Yes or no? So this is a question for you. We'll see how how you answer the question. See lots of votes going in. So we've stopped the poll and you are for the most part correct. The answer is no. A resident does not own the parking spot in front of their home, although I bet many homeowners, most homeowners wish that they did. So here's a question for you, Dave. My neighbor always parks outside my house and it drives me crazy. Is that legal? So
I think that happens to a lot of homeowners, that you look out your front window and say, why is this person parking in front of my yard when their yard is right there, and why aren't they parking in front of their yard? Or there's just so many cars parked in the neighbor's house that they spill over into other yards. Unfortunately, as the poll's correct, and as you mentioned, that homeowners don't own the street outside their house. The street is public property, and people can park there as a general rule. Now, however, having said that, there are some ways you don't need to, there's more to it than that, is what I'm saying. And I want to address the self-help situation first, because of course, going to your neighbor and asking them may resolve it. And there's stories, I think actually on the People's Law School website, about a person with mobility issues, and they just approached their neighbor and said, this is a problem, and then it resolved it. And I think keeping in mind that this is your neighbor, that is your first step. If you can resolve it before you go and start threatening things, or as I'll mention, talking to the bylaw officers, that type of stuff, that's your first step. One other thing I wanted to comment on, I think there's some mention in it somewhere that I read about that homemade signs saying "do not park here" don't have any legal effect, and that's absolutely true. I just wanted to go take one step further and say the website is not encouraging anyone to try the homemade sign first, because you can write a little sign that says "don't park here." That's okay. You don't want to try to make your sign look like a city sign. I think that's probably obvious, but you can't be going signs that are impersonating signs from the city saying no parking, anything like that. Putting cones on the street, that kind of stuff. I'm sure it's contrary to some bylaw, and you can, I'm sure, get a ticket for it. So we don't recommend that. If you want to put a nice request on your property saying don't park here, I expect that would be fine, but you can't try to impersonate an official sign. Now,
I never thought of that as an idea, but
yeah.
it could work.
I read the website and said, I wonder if that could be misinterpreted somehow. So I wanted to make sure no one thinks that that's a good idea. But so as I said, you're not completely out of luck, and the city bylaws often do address who can park outside your house. And I think a lot of people will actually be surprised about how strong those bylaws are. And actually, in fact, I was surprised to learn this. And in Burnaby and Vancouver, for example, local bylaws prevent parking of more than 3 hours in a day, between 8 in the morning and 6 at night, in front of any home or business that you don't own, or you don't work for. So essentially, this is exactly the situation. Someone parks in front of your house, and they park there 24 hours a day, or all day, and they don't work there, and obviously, it's your house, so they don't live there. And you can call the bylaw officer, and the city will enforce that 3-hour bylaw if the homeowner or the tenant who actually lives there, or the business owner, I assume, makes a complaint. So if you're in those neighborhoods, that is a very strong option for you. Now, you have to weigh that in terms of how you want your relationship with your neighbor to go, and maybe it's worthwhile talking to them before you start calling the bylaw officers, especially they may not be aware of that bylaw, and I don't think many people are. And in other municipalities like North Van and Surrey, for example, the parking is available on a first come, first served basis. So you have to look if there's any street signs or anything else that's posted otherwise. Although usually in those two neighborhoods, for sure, in most places, they have some sort of ultimate parking allowance. And for those two neighborhoods, it's 72 hours. In Kelowna, for example, it's only 24 hours. So if someone's just parked there for days and days, or in Kelowna only 1 day, then you also have a remedy through the bylaws as well. So, and the last thing is sort of the obvious one. Look around the spot. If there's fire hydrants or the parked in front of the driveway, and some alleys have special rules, you might have more rights depending on exactly the location where they are parking.
Excellent. And that's really good to know. I mean, it's really nice to know that to get the clear answer, it really is a question of looking at the municipality and what is acceptable in or what's acceptable in Kelowna, for example, might not be acceptable in Vancouver. So, so that's really helpful. Thank you.
Yeah.
Turning to the next question, we also get a lot of questions about fences, especially in the summer when people are usually doing their home construction projects. So here's a case. The fence is looking shabby. I want to replace it. Who pays for the cost of rebuilding a new fence, of building a new fence, sorry?
It all comes down to where the fence is. If the fence is completely on your side of the property line, it is your property, yeah, which means that you fix it, you do whatever you want with it, take it down, you've got control over it. The more complicated, and vice versa, if it's on the neighbor side of the property, it's their deal. If the more complicated situation is whether you or when you've got the property line and you've got the fence right over top of the property line, and in that case, you are deemed at law to be equal partners in the fence. And generally, each neighbor has to pay half the cost of building or repairing the fence. So essentially, your first step is clear. Then, if it's on the property line, and this isn't exactly the question, but if you don't know where your property line is, what you want to have is a land survey. There's little iron spikes in the land, and the land surveyor will go out there and they'll do you essentially a map called a survey of where the property line is, and then from there they'll mark major landmarks like trees and other things that they can pinpoint, so you get a really good idea of where the property line is. And the fence is only so thick, but often they do try. Previous owners of the houses will have tried to put the property line or put the fence right over top of the property line, so you can pin that down. If you've got one of these fences that is on the property line, like I said, you're usually splitting it 50-50, the cost of repairing it or replacing it. But there are a few exceptions. And number one, I think this comes up probably the most often, is that one of the two parties, you or your neighbor, we'll say it's you want a fancy fence. And the neighbor says, I don't want a fancy fence. I want the old Home Depots, or just put the pieces together and nail them in. I want that kind of fence. And the law is that the person who wants the fancier fence has to pay for the extra amount. So not the whole amount of the fancy fence, but whatever the increase in the cost is compared to the basic fence your neighbor wants. If you just go ahead, and this is really important, I've now told you that you're equal partners in the fence, but if you just go ahead and replace the fence on your own without talking to your neighbor first, you're liable for it. So you are equal partners, but you're not going to go around and suddenly sue somebody for their contribution for the fence if you haven't gone and talked to them about it first. And so, and preparing for the worst, if something like this did go to litigation, it's good practice to get some record of your communication. So if you talk to them and doesn't get anywhere, follow it up with an email or a letter or even a text message that you can take a screenshot of, some documentation that you actually have approached the neighbor and said the fence is coming apart. You take pictures of the fence showing it coming apart before you do anything with it. If you don't prove that, then you're going to be stuck replacing the whole cost of the fence, and you won't have any recourse against your neighbor. There's a couple of strange specific situations, as if you're sharing or if the boundary line isn't with a neighbor but with the government, then you have situation, and typically it's like you don't have a neighbor over there, so you're on your own to replace the fence. If you're the one that damaged the fence, either on purpose or by negligence, you somehow smashed the fence, you are on your own to replace or repair that fence to the state it was in before you negligently smashed it or did it on purpose. if there's for some reason urgent repairs to the fence, and I can see why there'd be urgency in case of animals or other things in the backyard. There's some reason why it has to be done right away. And the key is right away, meaning before you can ask your neighbor for their consent to doing a repair. Uh, if you can prove it's urgent, and best would be if you can prove you try to at least try to get hold of your neighbor if you had to do the repairs, then there's cases that show that you can recover some of the money that you had to spend on the repairs from your neighbor if it comes down to it. And I expect in those cases it would be under $5,000. So you'd be looking to the CRT if it had to go that far. Yeah.
Excellent. Thank you very much, Dave. Looking at the next question, we might see some similar parallels. So my neighbor wants me to cut down my tree because of a branch that hangs over onto their property. What are my options?
Right. And this is one where it really depends on the circumstances. And I like the graphic of the tree there in terms of all these things hanging down and a big pool underneath the tree. Because it'll get into because it'll get into what's actually happening with the tree. First step is, of course, as always, try to talk to your neighbor about it. It sounds like they've already had communication because the neighbor wants to cut down the tree because of a branch that hangs over his property. So so if you can't work it out, then the next step is to figure out what your rights are. And in this case, it's almost what your neighbor's rights are too. Because if there's a branch that, even if the tree is 100% on your, even if there's a tree that is based 100% on your yard, so the trunk and the showing roots are all on your side of the property line. If there's a branch that hangs over into their property line, your neighbor's property line, they have every right to cut down that branch up to the point of the property line. So they're not trespassing in your yard by going in there and cutting anything down. They're just going to the edge of their yard and cutting the branch down. That's in a sense the branch is trespassing into their yard, so they can cut that down. So if that's a big complaint, is that the branches is hanging over into their property, the easy answer is, well, you guys should just cut that branch down. Don't cut my tree. No one wants to cut the tree down. You can do this yourself to your neighbor. And as the owner of the tree that has the overhanging branch, there's not much you can do to stop them from cutting that branch off. Now, it gets a little tricky if if for some reason that won't work, and the tree is well, there are ways that they could call the tree a nuisance, and the examples you see are dumping a lot of fruit or debris or other things in their yard. And you think from a practical perspective, well, why wouldn't you just cut the branch down? Wouldn't that solve the problem? But assuming that doesn't work some reason, if you can show that your tree is a nuisance to them, then they can try to bring something against it. But even then, to answer the question that's posed on the thing, you don't have to do that. If they want to make a complaint, then you can deal with it. But in terms of your options, you don't have to cut your tree down until they make you do that, essentially. And I'm sort of speculating of what could be the problem here. If their complaint is, or if their real complaint isn't the branch, but that the tree is blocking their view or the tree is shading their yard, those aren't nuisances. They can't make you cut your tree down because it's putting shade on their yard, or it's blocking their view. That's just the law that the courts have made, and that those aren't nuisances. So I think that's basically your option. It's almost advising their rights of cutting down the branch, and then anything further than that is up to you about whether you want to do it, or if they want to take some kind of severe step to say that your tree is a nuisance.
Excellent. Thank you so much, Dave. Our next question is, my neighbor is using our unfenced side yard as an extension of their yard. Are they trespassing? Is that an encroachment?
And this is one where the legal answer is yes. You could put your fence in the middle of your yard, for example, and the court's not going to, or the CRT or the court's not going to say that you somehow forfeited the rest of your yard. Your property line is your property line, regardless of where your fence is. So if your fence is more onto your yard, creating sort of a gap between the end of your fence and your property line, and your neighbor just sort of is using that gap, they are trespassing by crossing your property line to use that space. There's no doubt about it. In all the questions we've got in terms of ones that should be able to be resolved by negotiation, this might be the best one. Typically in these situations, either the neighbor doesn't know where the property line is because the steel or the iron spikes that mark it are buried, or there's no survey done, or something, or also likely they just don't think you care. So it's at the back of your yard, or you're not seeing it anyways because of course your fence is there, and they are just proceeding as if they're going to use it until you say something otherwise. So if it is bothering you, step one in this case is absolutely to approach your neighbor. And if it's not resolved amicably, this is one where the legal rights are so clear that they're obviously encroaching into your property that you should be able to exert a little bit more pressure on them and get them to come around, because there's no real argument here, especially if they're, I think I read that they're putting up garden decorations on your garage wall. Well, clearly, that's just not permitted. So if you want to enforce your rights on that, you can, but it is a question of whether you want to enforce them and how much and how strongly. So at the end of the day, the answer is yes, they are trespassing. It's an encroachment onto your property, but the soft approach was probably the best approach for at least the early stages of it.
Exactly. And thank you, Dave. And I think what you're highlighting there too is yes, you may have the legal right, but when it comes to your neighbors, you live next door to them or you live very close to them. And so how you choose to deal with it obviously is impacted by that relationship. And we'll talk a little bit more about that as well. We've got another question coming up a bit later. Turning to our next question. I don't know if anyone who's watching can relate to this one. My neighbor's yard looks like a scrapyard with old cars, tools, and random appliances strewn about. It's an eyesore. Can I do anything about it?
Yes, you can try, essentially. Now, people have the right to, it's their property, just like we said before, the fence is on your side, it's your responsibility, and if the branch goes on your side, you can cut it off. The same principle of, you can almost do what you want on your property applies here in the bad way, in that your neighbor can have, to an extent, control over how they keep their yard. And I say that to an extent. The first thing I wanted to point out, though, is up to this point, I've been emphasizing and encouraging people to use self-help and try to work things out with their neighbors. And in this case, I expect a lot of people feel this urge to I just want to go out there and clean it up. And unfortunately, that is the worst thing you can do, because if you go over, trespass into their yard, start cleaning up all the junk over there, you are exposing yourself to being sued. And no doubt, I shouldn't say no doubt, but depending on who the person is who owns this house, they might allege that rusty drill that was sitting in the rain for 6 months was in fact their great grandfather's and an antique, and now they're suing you for $5,000 in the CRT or something like that. You just don't want to get anywhere near that by trespassing onto their yard and cleaning up or anything. So this is a case where, while you should still talk to them first, don't go and try to fix it for them. Even if you think at the end of the day you're going to do a benefit to them, it's not worth the risk. Now, there is something called a visual nuisance, and it's a harder case than the smells or the noise, because those are things that are escaping from their yard or their property onto your property and impacting you. Here, there's nothing really escaping. It's just that it's a visual problem that every time you look at it, it's an eyesore, essentially. It causes problems. Now, having said that, the old cars, tools, random appliances strewn about, I've seen some cases with like mattresses and other stuff that's just piled up, and eventually rats and bugs and mice will move in and get into that. And then that's a much better case for a nuisance, because everyone will agree that having rats running around everywhere and a giant rat home in the neighborhood is a problem. So if you can show that the rats, for example, are escaping because they're coming onto your property, that's a better case for the nuisance. But assuming for the time being that it's just this old car tools and appliances, and there's no insect or other things happening here, you're if you're a homeowner, private residence, your best bet is the local bylaws. And most communities do have local bylaws to control garbage and junk and abandoned vehicles, overgrown yards, that stuff. There's generally they're called unsightly premises bylaws. One example that I read was on Richmond's, for example, says it addresses the excessive accumulation of garbage and buildings tagged with graffiti. Vancouver's even says that you have to meet the tidiness standard of other houses in the neighborhood, which is kind of funny if you think about it. If all the houses are in terrible repair, then I guess you'd have a tougher time claiming that one person to clean it up. But that's what the bylaw says. So you can go to the bylaws, say this is unsightly, make a complaint. If they agree with you, then they can issue tickets and force people to clean up. And I haven't had to deal with this, but I think ultimately, if they refuse to clean up, the bylaw people can hire someone to do it and stick the neighbor with the bill to do it. I haven't looked at that for a long time, but I think that is something the bylaw, the power for the bylaw officers to do. Again, though, before you start calling the bylaw officers, it's best to try to work it out beforehand. But that's a legal remedy if it comes down to that. If you're it's a little bit different if you're in a strata, because most stratas will have bylaws prohibiting leaving garbage around their unit, like outside their units. And usually it's common property that they'll be leaving their junk. And the strata should be all over that in terms of a breach of the bylaws. So if it doesn't work out after a warning, saying, I don't appreciate all the cardboard boxes outside the front door of your place into the common area of the hallway, if they don't fix it, a complaint to the strata should do it. As mentioned before, the strata has a duty to investigate these kind of complaints and do something about it if they do find that the complaint is warranted. And in this case, a few photos of a few time-dated photos of the mess outside their front door should cover this off. As a tenant, we get back to that first answer about you have a right to quiet enjoyment. This is if the unit is impacted by this garbage being all left around it, you go to your landlord and say, you've got to deal with this. And if they refuse, you have a right with the residential tenancy branch.
Excellent, excellent. Well, and it's encouraging to know, Dave, that you do have options. So it sounds like for homeowners, you're looking at the municipal bylaws, you're looking at having somebody help you enforce those if you meet the threshold. And if you're in a strata, you've got your strata council. And if you're a renter, then you've got your landlord. So there is somebody that you can turn to. I mean, that is apart from maybe speaking directly with your neighbors as a first step. So thank you. That's really encouraging. We've talked a lot already about different steps you can take when you do have issues come up as between your neighbors. This question is, what practical steps would you recommend when dealing with a neighbor?
Yeah, in preparation for this webinar, I reviewed all of the suggestions that was on the People's Law School website, and they have a section devoted to what you can do in terms of practical steps of working through it with your neighbor for each different category, for fencing issues, for nuisance issues, anything that we've talked about today. There's a category there that walks you through it, and I thought they were really well done, and they all start with going to talk to your neighbor first, and that is the best way to resolve all of those. And if that doesn't work, either before or after that, I recommend you consider what steps you can take and where your legal position is. So what are your rights? And then you can go down to documenting the problem. Writing a letter or an email will do, but some kind of written statement or written evidence. And the reason why that's so important is not only because if it does go to litigation at the CRT or at the courts, obviously you're going to be much better off with something you can show to the court saying, look, I sent this letter on this day and it was ignored. I did my best to work this out. Yeah. If it's a legal requirement like repairing a fence that you need to get their consent, perfect. Even if it's not, though, just showing the judge or the adjudicator, the CRT, that you did your best to try to work this out directly will get you a lot of understanding from the adjudicator. So it's always a good idea to get some evidence there. But even leaving the litigation side alone, just a random chat across the property line with your neighbor can leave people with different understandings of what they're supposed to be doing. Sending a letter is going to be treated in 99% of the time more seriously. So if you don't get anywhere with a talk, don't give up then. The next step of writing a letter or an email at least can get you that self-help remedy where you still have a good relationship with your neighbors. And then from that step forward, you've got other options like trying a dispute resolution service. Usually that means you hire a mediator to try to work it out between you. You've got the bylaw option, and then you've got the lawyer's letter, and which is a strongly worded letter from your lawyer saying you've got to take whatever action is required or we're going to sue you. That's basically what it boils down to. And then the CRT, if that's the option. So, but I think the key and what I like about the People's Law School website is that it does start out with the practical steps to try to resolve this before you start spending thousands of dollars on lawyers, or just the time put into and potential cost of the CRT as well. If you can work this out with your neighbor, it's so much better because you will have an ongoing relationship with this person, essentially no matter what happens.
Exactly. Thank you so much, Dave. And thank you for referring to the website. There are a number of resources available. And as you pointed out, in relation to each of the categories, so fences, parking, noises, there's some suggestions on how you can approach your neighbor. There is a draft template of a letter, suggestions on what kind of evidence you might want to put in your letter. So absolutely, those are resources. And as you point out, having that written documentation can be really helpful for those reasons. And also even just to articulate what it is that is the problem. So all that is really helpful. You mentioned, Dave, there's sort of this threshold between, when should you see a lawyer? What about the CRT? What are your thoughts on which avenue to take?
Well, when you recommend seeing your lawyer, there's the practical side of it is really when you've exhausted your other options, and the other, I don't think all other options, but the other practical options. So, well, actually, sorry, let me take a step back from that. If you're unclear of what your legal rights are and you want to negotiate with your neighbor from a place of understanding what your rights are first, you can go to see a lawyer first. I would only do that after you look at, for example, the People's Law School website or other resources that are online, because there is a lot of good information out there. But if you've got a complicated problem that's not addressed, you can go see a lawyer just for an opinion, and just you can get sort of a memo done, and depending on how complex it is, the cost is going to rely on that. Be concerned though that at $400 an hour or some other fee like that, or even junior lawyers who are charging say $200 an hour, the cost can get really high up, and some of this legal research can take a few hours. So you should be prepared to spend at least sort of $1,000 on getting some piece of paper that will have case law in it and the relevant sections of whatever statute applies, and or maybe your bylaws, whatever the situation is. But it will cost some money. But then at least at that point, you're armed with, okay, I know what my legal rights are, and I can go negotiate with my neighbor in terms of knowing what I can ask for and what I can't ask for. Now, I think the question is more to do with at what point do you sort of escalate the dispute? And because you've got recommend seeing a lawyer, or what about the CRT? And that was what I was getting to. And once you've exhausted those attempts to work out an amicable solution, then there is an option of going to a lawyer and saying, okay, can you write me a letter to my neighbor and say, here's what you've done, here's what my rights are, client's rights are, and correct this by this date, or here's what's going to happen. And the consequence is going to be small claims court, a CRT, or if it's an egregious issue, if it's more than $35,000, you're going to Supreme Court. And that's the threat at the end of the letter. So you can imagine once your neighbor gets that kind of letter, your relationship's soured. It's going to be really hard to rebuild anything after that. So it's only when it really needs to be done, and when you're willing to pay the $1,000 or $1,500 that letter usually takes. I'm sorry, I shouldn't quote fees on that, because if you did the opinion first, the letter should cost less because you already know the facts and all that. But you should be able to be willing to put significant money into it at that point. So it's got to be an important issue for you. And the CRT, this is where all the strata things end up essentially, and under $5,000 claims. And I've worked through one of them with the actually a fellow employee here who was having trouble with her strata, and it's a pretty good process. You don't need to miss work to do it. You can run your side of the case on your own time. There's deadlines when you have to do things by, but it's not like you need to be present on a Thursday morning downtown for court, or a 2-hour settlement conference at small claims court at some point when you have to take time off work and it's inconvenient to you, and you don't have a say of when it's scheduled. So it is the best option for when you get to that point. So if you can't resolve it and you don't want to spend the money on a lawyer, you can go to the CRT. There is some risk for the CRT filing fees if you lose your case, but it is still a really big time commitment. Even if it's on your own time and your schedule, it still can be a lot of time to put into it. So you should be ready to do that before filing it on a whim, essentially.
Excellent. Thank you so much, Dave. And there's another resource that I'd just like to highlight. It's on the People's website, and it's through Mediate BC. And they offer a couple of services that might be of interest to anybody who's watching who has an issue with their neighbor. And one is a virtual pro bono clinic, and that's free. It's a monthly clinic on the first Wednesday of the month. And I believe there'll be a link in the chat to that, and we'll also provide a link to that on the webpage that hosts the recording of this video. And then there's also the Quarantine Conflict Resolution Service, also offered through Mediate BC. And that is basically a low cost or free, depending on your financial situation, mediation service. And there's more information about that on the Mediate BC website. So that's another way, you're talking about the relationship with your neighbor. If you're trying to preserve that relationship and looking for some additional support in resolving problems, that's another place you can go. So at this point, Dave, we're going to turn to some live questions. I'm just going to exit my screen share so that I can pull up the chat. I can't see it when when my slides are up. And as I go through the Q&A, I have one question that came in from somebody before the webinar, and it's this: who's responsible for maintaining a hedge that runs along a property line? All the trees except 2 or 3 share the property line, and the rest of them are 3 to 8 inches away from the property line.
So it runs along the property line, and there's a few trees that aren't on the line, but I assume they're within that close. I assume on the other side of the property line.
I assume the same thing, that it's a few inches past the property line of the person who's asking.
Okay, so I think there's 2. And who's responsible for maintaining the fence? Well, the hedge. Well, you've got this, I guess, even if the trees are on the other side of the property line that comprise the hedge, you'll still have, I understand the issue, you got the overhanging branches issue. So they're coming onto the person's yard, or the asker's yard from the other side. So it doesn't really matter if it's on the property line or on the other side, close to the property line. If the branches are overhanging, you've got the right to deal with those branches. So if you want to cut them off up to the point of your property line, you are able to do that. I guess the difference is, the other thing you've got to be careful about is if they are on the property line, though, while you have the right to cut the branches and things, if they're on the property line, they're considered joint property. So you can't go and say, well, they're half on the trunk's half on my property, so I'm going to cut down half the trunk. You're going to destroy the tree. So if you want to cut trees down or take them out, you need to have the consent of the other party to do that as well. So you can only take it so far. You can cut the branches down and maintain your side of the property line, the hedge on your side of the property line, but you can't go so far as to damage or destroy the tree.
Okay, excellent. Thank you so much, Dave. I have another question. Now, this is a question that's come in live and a 9 upvote. So it's a question that a lot of people want to know about, and it's about smoking. And there's multiple parts to the question. So what I'll do is I'll ask you the question, and then to the extent that you can sort of address them, that would be great. So hi, a question about smoking. Where can renters smoke at a detached house? Do my downstairs neighbors have to leave the property to do so? What if they're smoking cannabis? Do the rules change?
So for the basic rule for tenants is you got to look at your agreement with your landlord, and the landlord, it should specify where you're allowed to smoke and where you're not allowed to smoke. That is the first place you go to it. So, sorry, to the answer, where can you smoke in a detached house as a tenant? There's no one answer that'll work for that. It really depends on basically what your house is and what the property or the tenancy agreement you've got going with your landlord is. And like I said before, with smoking, there are these human rights issues, especially with cannabis. If it's medical cannabis, then you've got more rights because you've got a disability that requires treatment than you will for recreational cannabis. So it's sort of an impossible question to answer on a general basis. But step one is look at your tenancy agreement and you go from there.
Excellent. Thank you so much. And here's another question. And again, it's about smoking. It seems to be that that's a really common concern. In a non-smoking condo building, a neighbor smokes, which fills the hallway with smoke, smell, and also comes into my apartment. The person admits that she smokes. I told her that it bothers me. She's been warned a couple of times by the strata. The smoking stops for a short time and then it starts up again. What can I do?
You've done it. Yeah, you've already complained to the strata there, and when you say non-smoking condo, I take that to mean you've got in your bylaws it's a non-smoking building, so there's no smoking permitted, which makes sense of why the strata would be at least ineffectively monitoring it. The strata should be issuing fines, and they don't need to do, they're not done at $200. It's not like you pay your $200 the ticket and then you can keep going back to smoking. They can keep issuing these fines until they basically get a remedy from it. And if they're not doing enough to protect the quiet enjoyment of their other tenants, then you have a right. You see these in the CRT cases. It's one more case against the strata where they're not doing enough to either investigate or to enforce their own strata bylaws. So that would be, it's unfortunate because you shouldn't have to be the one to make the strata enforce their bylaws, especially in a case where it seems like they already agree that there's a problem. They're just not reacting forcefully enough. But at the end of the day, if they fail to do it, you do have rights to basically make them do it.
Excellent. Thank you so much, Dave. I'm going to take the next question. Looks like a number of them have been answered. This one is, my neighbor's kids continue to play on our driveway. We have the incline. We've asked them not to for a variety of reasons, but we're also concerned about what if they get hurt when they're playing there? Can we be sued or blamed?
Yes, you are right to be concerned. Number one is from the question I gather, you already know that they're trespassing. So kids aren't exempt from trespassing, just like adults aren't exempt from trespassing. And the people to deal with are the parents to keep their kids off the yard. But yeah, if the conversation is along the lines of what's your problem? They're just kids playing on your driveway. You have it. There's an act called the Occupiers Liability Act. And if even if you hadn't invite them onto your yard, if you know they're there and they're playing and there's something unsafe for, I'll just make up suggestions, but there's a lip off your driveway and the kid hits it just wrong and a ankle gets broken or a knee gets broken or something like that, they're going to say, as preposterous as it sounds, that you kept your place unsafe and they have a right to sue you for those injuries under that act. And you'll have defenses to that and things, but this is what you want to avoid, is even having the litigation come up, not whether you'd win the litigation or not. You just don't want to get into it. So you do have concerns about that, and which would push you farther to tell your neighbors in more strongly fashion that they shouldn't be trespassing on your yard.
Excellent. Thank you so much, Dave. So Dave, I see we're pretty much at 1 o'clock. If you're okay for time, I'll ask you one last question before we wrap up. Does that work for you?
Sure.
Okay, super. This one, I'll just read it to you. A huge construction project next door, fully permitted, lasted 9 months. Subcontractors were often on my property, which is very close to my neighbors. There was also some damage to my fence and a written promise to build a deck railing in exchange for access to my property that was not fulfilled. Is the nuisance of them being on my property and not doing what they promised over and above any damages something I can get money for? I spoke to the general contractor several times.
What jumps out at me there is probably your easiest path to a remedy here is your breach of contract issue. So you've got a promise that in exchange for them having access and I assume causing some damage to, I think you said it was a deck, that they're going to rebuild your deck. That's a contract. If they promise to do that and they're not, and now they're resiling from that or backing out of it and saying, oh, they're not going to, or they're ignoring you and they're not going to pay for what they promised to pay you. Yeah, you can sue on that. And the cost of it is going to be whatever they promised to fix. So if the deck repair was $2,000, then it's $2,000 and you're in CRT. If it's $15,000, then you're in small claims court. That'd be the way that I'd approach that.
Super. Dave, thank you so much. You have really answered a lot of questions here today, and we really, really appreciate it. We're going to wrap up, but before we do that, do you have any last words that you'd like to share on this topic?
No, it's been a pleasure, and there are lots of good questions today, and a wide variety of topics. So I hope I've been helpful.
You've got a slide with a link to the People's website on our neighbors, concerning our neighbors content, and also to your firm website, Dave, with your publications. So thanks again, Dave, for being here. Okay. Thank you, everybody, for tuning in. It has been such a pleasure, and we'll look forward to seeing you at our next webinar.